Within the context of the Ripple XRP issue, it was stated by Cohen G. that the SEC had requested that Judge Torres rule against Ripple. This request coincided with the post made by the SEC. This message was deemed to be in violation of securities laws by SEC, which alerted the federal court of the violation. In the remedies brief and other materials, executives from the cryptocurrency company Ripple accused the Securities and Exchange Commission (SEC) for making disrespectful remarks. Included in this package are permanent injunctions, disgorgement, prejudice interest, and over $2 billion in costs associated with civil litigation. The measures that Ripple took that disrupted the bull market are punished by redactions. The final conclusion brief issued by the United States Securities and Exchange Commission does not make any allegations of recklessness or fraud. The court listened to the public brief that the SEC had filed against Ramesses. In the brief, violations of Section 5 of the Securities Act of 1933, unregistered offers of XRP and institutional sales were noted. The decision that was made by Judge Annalisa Torres on July 13 on the summary judgment demonstrates that the Securities and Exchange Commission has not argued any fraud and is solely targeting Ripple's expansion, despite the fact that a lawsuit has been filed. The Securities and Exchange Commission has issued an order that requires Ripple to pay disgorgement in the amount of $876 million. Additionally, the SEC is demanding a draft judgment in its favor, as well as a civil penalty and pre-judgment interest to the amount of $1998,115,940. The Securities and Exchange Commission asserts that two institutions accounted for the majority of Ripple's post-complaint XRP sales. This led to investors suffering losses as a result of the company's failure to disclose discounts to institutional investors. Ripple is accused of continuing to defy laws, misrepresenting the ruling, and willfully avoiding compliance with securities regulations, according to the Securities and Exchange Commission (SEC), while the CEO of Ripple has been critical of the SEC. The chief executive officer of Ripple, Brad Garlinghouse, stated that the $2 billion penalty is unreasonable because there are no allegations, let alone findings of fraud or recklessness. There is not a single example that can be compared to this. Garlinghouse, on the other hand, draws attention to the SEC's misuse of authority in the debt box case and its lack of faithful allegiance to the law in the Ripple case. The Securities and Exchange Commission appears to be merely punishing and intimidating Ripple and the entire sector, according to Stuart Alderoty, rather than applying the law. On the 22nd of April, Ripple will deliver its position to the court, and on the 6th of May, the Securities and Exchange Commission will file its answer. The price of XRP is quite high. The corrective brief, according to those who support XRP, did not contain any unexpected facts. On the other hand, the solicitors for steel and cigarette clients, Bill Morgan and James Frill, stated that Judge Torres placed Odell's sales, together with those of institutions and Ripple's, in Category 1. Despite the fact that Fred Rispoli is of the opinion that the action will have an impact on Ripple, I believe that the court will provide the parties sufficient time to negotiate the penalties and fines. A member of Ripple's legal team has expressed the hope that the SEC will have an advantage in the event that the company does not alter its business processes in response to Torres. If this is not the case, the judge will evaluate whether or not the new sales are suitable for Ripple. There is a possibility that XRP, which has been in macro-triangular consolidation for almost 5 years thanks to Bitcoin and is supported by Ripple Labs, could soon see an astonishing breakthrough. DEX demonstrated that inside over the next few months, XRP would attempt to retest its all-time high. Significant progress has been made. By virtue of Ripple Labs and the payment technology it has developed, the alternative cryptocurrency has also chosen a form that resembles a cup with a handle. This is a design that typically comes before a substantial move. XRP's price has skyrocketed, and its liquidity has also increased. A study that was conducted on the legal battle that Ripple Labs was having with the SEC has found a new step that could be extremely significant in the Fred Rispoli case. A legal expert says that there is a 40% likelihood that a significant event will take place. The SEC said yesterday that it would be fining Ripple a total of $2 billion. The lengthy legal battle that Ripple and the regulatory authority have been engaged in has resulted in this consequence. In the instance of a well-known Ripple backer, the demand, which is anticipated to be included in documents in the near future, represents a turning point. Ripple was accused of committing multiple serious violations by the SEC, and the individual conducted an investigation. Ripple contests the claims made by the SEC and raises issues about their legality. As a result, the requirement that the regulator demonstrate that investors have suffered harm is contested. Nevertheless, Ripple emphasized that the action has significant repercussions for Ripple as well as the cryptocurrency sector as a whole. Both a 40% possibility of a drawn-out legal struggle and operating constraints for Ripple were the two eventualities that he predicted would occur. Factors that are essential because of Rispolli's motion studies, it was decided that a final agreement would be reached after the verdict, and I believe that the probability is 40%. Rispolli brought up a number of significant challenges, one of which being the contentious subject of selling alternative cryptocurrencies at lower prices to institutional purchasers. Rispolli brought to light a number of additional significant concerns. To put it another way, ordinary investors and members of the cryptocurrency community are not concerned about the potential impact that these reductions could have on the XRP market. While it is quite probable that Ripple will prevail in the matter of the amount of money that is owed, it is also possible that it could lose in the matter of what is permitted moving forward, which would necessitate an appeal to the second court. In the course of their talk, Rispolli also brought up the topic of XRP sales. Following the conclusion of the matter, doubts were raised regarding the revenue streams of the company as well as the contracts with institutional buyers. He emphasized the significance of the forthcoming ruling that the court would provide regarding the legitimacy of these contracts. As a result of this ruling, Ripple's business activities might undergo certain changes. In a thought-provoking comment, Rispolli brought up the subject of how the discounts offered to institutional buyers influenced the progression of XRP prices. Additionally, he discussed the ways in which big investors might influence market dynamics in order to increase the liquidity of XRP. The arrival of the automated market makers, which was just released, was something that a lot of people in the Ripple community were looking forward to. XRP trading has increased significantly as Worlds on-demand liquidity continues to gain popularity on a regular basis. XRP continues to be one of the top 10 most valued digital assets, despite the fact that Ripple is now engaged in a legal dispute with the SEC.